everybody. I am told that we are live. My name is Eileen Lawrence. I'm an attorney in Round Rock, just north of Austin. And I'm going to be talking with you today about the Declaration of Guardian for Minor Children. I'm going to start off with, I'm trying to talk a little slowly because I'm expecting that some people are going to be a little slow to join. I know that's how these things work. But let's see. I'm going to start off with the agenda. So first I will talk about what Texas Legal is, since Texas Legal is putting this on. And then I'll talk through some key definitions related to the Declaration of Guardian for Minor Children. Talk about what it does, what that declaration does, how a court determines who should serve as your children's guardian, what you should think about when deciding who to name as your children's guardian, and then any other documents. I'll talk through some other documents that you may need to protect your children in case of your death or incapacity. I'm just going to note there's a comment section. I think if you're on Facebook or on YouTube, you can type questions in there, and I will try to answer them as we go through. There may be some that I'll save till the end, but I'll try to get as many of your questions answered as I can. All right, so first of all, what is Texas Legal? So I'm going to read the script first. This is the script they gave me, but then I'll give you some of my own thoughts. So Texas Legal is a statewide nonprofit legal plan which provides its members with affordable legal help. As a member of Texas Legal, you can protect yourself and your family from the burden of high legal costs. Their plans include coverage for estate planning, which is part of what we're talking about today, family law, DUIs, and much more. To learn more about Texas Legal and view their plan options, you can click the link to their webpage, which is found in the description of the webinar. It is also just really easy to remember. It is texaslegal.org. They have a lot of great information there. So go off script a little bit and just say that I opened my own estate planning practice in 2020. I was licensed in 2003, so I've been an attorney for a while. I didn't know about Texas Legal until a little bit before I started my own estate planning practice. And it is such a wonderful program. It's been wonderful for me as an attorney. The reason I started my own practice was to provide affordable legal services to low and middle income families in Texas. And Texas Legal is a great way for me to be able to offer my services in a way that's affordable. So they're easy for me to work with. I hear good things about them from my clients who use them. So I know a lot of people who work for schools and local governments in Texas, and the state may have Texas Legal membership through your employer, so you may want to check on that if you're not sure. And if not, they also have individual plans for anyone in Texas, regardless of income, it's just a great service. Okay, but they didn't ask me to talk about that. They asked me to talk about declarations of guardian for minor children. So that's what I'm going to do now. I wanted to talk through some key definitions first. This may seem pretty obvious, but this is something that does vary by state. When we're talking about children in the context of estate planning, wills, powers of attorney, and declarations of guardian, a child or minor child is any child under the age of 18. So those are the children we're talking about. We will also be talking about two different kinds of guardian. Texas recognizes two different kinds of guardian in this context. The first type of guardian is what's known as a guardian of the person, and that is an adult appointed by the court, and I'll talk more about all of this throughout the rest of the presentation, who has the right to have physical custody of a minor child and is responsible for providing care, supervision, protection, clothing, food, healthcare, and shelter for that child. So when you think about movies about kids being adopted, like Annie, it's Daddy Warbucks who was given custody of Annie, of her person. He's the guardian of her person. The second type of guardian that Texas law recognizes is something called a guardian of the estate. And this is a little confusing because when we think about the word estate, a lot of times what we're thinking about is what someone leaves when they pass away, as far as monetary assets, bank accounts, and all of that stuff. That's what we think about when we think of an estate. But when we're talking about guardians, a guardian of the estate is a person who has the right to manage the finances on behalf of the minor child. So they can collect debts or rentals. So, for example, if part of what this child inherited is rental property, the guardian of the estate can collect those rentals on behalf of the child. They also, in Texas, have a right to access a minor child's digital assets. Digital assets, generally speaking, if you think of anything that you can get to online, anything you have saved online, social media accounts, things like that, those are digital assets. And minor children can have digital assets, but they would be managed by the guardian of the estate while the child is a minor. I did want to point out that although a guardian of the estate has the right to manage property belonging to a minor child, if the minor child is also the beneficiary of a trust, and this could be something that's either set up in a will, which is known as a testamentary trust because it's part of a last will and testament, or a trust that's set up in something like a living trust, which is kind of an alternative to a will. But in either of those settings, in a testamentary trust, in a will, or in a living trust, there's also other kinds of trusts, there will be a trustee named in that document to manage the trust assets. So any assets that are held in the trust, any bank accounts or real estate or anything held in that trust, would be managed by the trustee of the trust for the benefit of the child, not the guardian of the estate who would manage any assets that are held outside of the trust. It could be the same person serving as guardian of the estate and trustee, but it doesn't have to be. All right, so talked about guardian of the person, guardian of the estate, and then let's talk about what a declaration of guardian for minor children actually is. So this is a statement by a parent of a minor child appointing one or more guardians of the person and of the estate of the minor child. So it's a way for the parents to express their wish about who will serve as guardian of the person and guardian of the estate of those minor children. To be valid, the declaration of guardian has to be signed by the parent, and we have two options here, either written entirely in the parent's own handwriting or attested to in the parent's presence by two credible witnesses, believable witnesses who are over the age of 14 and not also named as guardian. So they have to be not named in the document at all, and over the age of 14. So I'm just going to say that again. It has to be a statement either signed by the parent, it must be signed by the parent, either way, and either written entirely in the parent's own handwriting or attested to in the parent's presence by two witnesses. That just means when the parent signs the document, the two witnesses need to be there, and all three of them sign in each other's presence. That's how we usually do it when we're doing a typical estate plan. We don't have the parents actually write it out in their own handwriting. All right, so now let's talk in a little more detail about what a declaration for minor children does. Like I said, it allows the parent of a minor child, while that parent has full capacity and is alive, to express their preferences about who should take care of their children, serve as guardian of the person, and who should manage their children's finances. So that would be guardian of the estate, if the parents are no longer able to care for their minor children. So most of the time we think about death. If the parents pass away and they're not able to care for their children, then the guardians would step in. But it could also happen in case of incapacity, if the parents are incapacitated and no longer able to take care of their children. It also allows the parents to express their preferences about who they would not want to take care of their children. If there are specific relatives, for example, they would not want to take care of their children, if the people that they've listed as preferred are all unable to serve, they're going to say, still strike these people from the list of potential guardians. So a few notes, these are some common questions that come up. You can name different people as your preferred guardian of the person and guardian of the estate. It doesn't have to be the same person serving in both roles. You can also, and in fact, I strongly recommend listing more than one possible guardian to fill each role, because you just don't know what's going to happen. You don't know when or if you would need a guardian, and you don't know who's going to be available at that time. You can't list co-guardians, two people to serve as guardians together, unless they are married to each other. So you could name, for example, your sister and brother-in-law, but you couldn't name your sister and your brother because they're not married to each other. So even though that is permitted under Texas law, it's permitted to name a married couple as co-guardians, I don't recommend doing that in most cases. I say think about the person, for example, if your sister and brother-in-law were to get divorced, would you want your kids to go to the sister or to the brother-in-law, and list that preferred person as your preferred guardian? That's my recommendation. So you'll list your preferences in the document. Who will actually be appointed as the guardian? Well, I feel like I skipped something. Okay, here we go. So we're moving to who will be appointed. So the guardians are actually appointed by a judge. It's done in a court proceeding. And the key question, the driver of all of this is, and the question the judge is supposed to answer with the help of the attorneys and the information that's presented to the judge, is what is in the child's best interest? That is the driving key question. With that said, the very strong, almost undefeatable preference is the other parent of the child. So, I mean, that makes sense if you're married and you have the kids together, that absolutely makes sense. But it is still true even if there's a divorce, even if the surviving parent has not had any contact with the children for a long time, even if there's not a good relationship between the surviving parent and the other child, that is still the presumption. The very strong presumption is that other parent, the surviving parent, should be the guardian. If there are no surviving parents, and if the parents did not create a declaration of guardian before they passed away or became incapacitated, then Texas law provides for a few different, a list of preferences. So first, we look for surviving grandparents. If there's more than one surviving grandparent, then the court's again going to go back to that question of which grandparent would it be in the child's best interest if that grandparent served as the guardian. If there's no surviving grandparents, then the court looks to next of kin, and again, looking at the child's best interest. If there are no relatives who are, quote, eligible to serve or interested in serving, if they're all saying, no, we can't take this on, then the court will appoint a, quote, qualified person. If a child is at least 12, they can express their preference as to who would be appointed as their guardian in writing. So they can say, I would like Uncle Joe to serve as my guardian of the person. The judge doesn't have to automatically appoint that person. They still have to determine if that preference is in the child's best interest, but it can be taken into account if the child is at least 12. Okay, so we talked about what happened if there is no declaration of guardian. If there is a declaration of guardian, so if the parents have signed a valid declaration of guardian before the need for this came up, then the court will respect the wishes that the parents listed in that declaration, even if it's not a relative, even if it's not a grandparent. So it could be a friend. That's fine, as long as that person is, we have three points here: qualified, alive, and agrees to serve as guardian. I'm going to talk a little bit more about that qualification piece on the next slide. So these are grounds for disqualification. So let's say you've named your best friend as guardian of the person for your child. They could still be disqualified if they themselves are incapacitated, they're in a coma, or, for whatever reason, they don't have the capacity to serve as guardian. They are incapable of serving as guardian. Maybe they're stuck out of the country, for example, or just unable to serve. They are, quote, unsuitable, which is a determination the judge would need to make. I had to put this part in quotes because I think this is the only place that I've seen this in Texas law. The person has been engaged in notoriously bad conduct, which seems to refer to applicable criminal conduct. So I use the word applicable because we're not talking about criminal conduct that wouldn't reflect badly necessarily on that person's suitability as guardian. We're not talking about speeding, for example. We are talking about things like domestic violence, child abuse, those types of things would disqualify the person. If there's a conflict of interest involved in the person serving as the child's guardian, that would also disqualify them. For example, maybe they would stand to inherit more money than the child would, or something like that, that would create a conflict. And then this is separate from the notoriously bad conduct. It's listed separately. If the person is subject to a protective order for family violence, they would also be disqualified. And so if your named person, I'm just going to go back to this here, is alive, agrees to serve as guardian, and doesn't have any of these grounds for qualification, then your wishes will be respected and that person would be appointed as your child's guardian. Okay, so next we get to what can be a really hard question for people, and that is, who should I name as guardian for my children? I'm going to tell you some criteria that I would advise my clients to use when considering who to name as guardian of your children. But I realize that not everybody has someone or more than one person who is going to meet all of these criteria. So if you are lucky enough to have several good candidates that meet all of these criteria, great. You can pick from that list and express your preferences. If not, then you're just going to have to go with, who gets the top 3 out of 4 or top 2 out of 4. And that is the unfortunate reality for a lot of people. But so in a perfect world, who would I name as guardian of the person of my children? And again, this is the guardian who's actually going to have physical custody of my kids. Absolutely, it has to be someone you trust. Someone who knows your children, who your children already have a relationship with, I would strongly recommend. Someone who shares your values, specifically around raising kids. And then I would say, if you have someone with experience raising children who's already done this before, or who is in the process of raising their own children, that is another good criteria to consider when naming guardian of your person, of your children's person. Okay, as far as guardian of the estate, very similar criteria. Someone you trust, someone who knows your children, who knows, for example, what standard of living they're accustomed to, and knows what standard of living you wanted to provide for them. Again, someone who shares your values, especially around money. And I'm going to say with this last criteria, not so much someone who has experience with raising children, but someone who has experience managing money and does a generally good job of it. All right, so those are the criteria to consider. And then last, I wanted to mention some other documents that you want to consider to protect your kids in the case of your death or incapacity. So some of these may sound familiar to you. I'm going to talk through just a little bit about all of these, but these documents, along with the Declaration of Guardian for Minor Children, constitute what we call an estate plan. So I don't like using that phrase because I think it's intimidating to a lot of people. When you hear that word estate, you think of rich people, maybe. But these are documents that really everyone needs, not just to protect your kids in the case of your death or incapacity, but to make sure that your own wishes about your kids and your money and your medical care are respected. So first, a will and a trust. So I mentioned this before, but with a will, you can include something called a testamentary trust that provides for the management of your assets on your kids' behalf if you pass away when they're still little. So that would be a will and a testamentary trust. I also mentioned something called a living trust, which is another option. A living trust says where you want everything to go when you pass away, like a will does, but it provides, it's a little bit of a different approach. And the differences between those two things are beyond the scope of this conversation, but I did just want to mention that. So both of these documents says where you want your assets to go when you die. You nominate a person to wrap up your financial affairs when you pass away. It provides for something called an independent administration of your estate. So in Texas, you can have either an independent administration of your estate or a dependent administration. A dependent administration is extremely expensive and time consuming. An independent administration is what you want, and you can provide for that in your will, that's what you want. It also, with a trust, especially either a testamentary trust or a separate trust, allows you to spread out distributions to your kids. So, you know, if you don't want your kids to inherit all of your millions of dollars when they turn 18, if you've passed away, you can spread it out and say, no, I just want them to get the first 500,000 when they're 18, and then, they can get the rest of it when they're 26, for example. You can spread those out and say how you want that spread out. You can also appoint a trustee to oversee those distributions to your beneficiaries. Then we have a statutory durable power of attorney, or a financial power of attorney. And this just lets you nominate someone to manage your financial affairs if you become incapacitated. Same with a medical power of attorney, or very similar with the medical power of attorney, you say who you want to make medical decisions for you if you become incapacitated. Then we have something called an advance directive, which people sometimes know as a living will. And that's where you express your preference for your agent serving under your medical power of attorney and your physician about whether you'd like to be kept comfortable or basically kept on life support if you're diagnosed with a terminal or irreversible condition. Then we have a HIPAA authorization. It's the same form that you see every time you go to the doctor saying who can access your medical information. Most estate plans include a HIPAA authorization that really can be used anywhere. It's like a universal HIPAA authorization. Then there's a declaration of guardian for you in case you need a guardian at some point. I didn't list it here, but we've spent most of the time talking about the declaration of guardian for your children. And then finally, there's a document called a final disposition of remains that says what your wishes are, if you have any, about organ donation, burial, cremation, and allows you to appoint someone to carry out those wishes for you. So you may not see the direct connection with all these documents and taking care of your kids, But I can assure you, even if your kids are not young when you pass away or become incapacitated, a lot of the times they're the ones who will end up making these decisions or having to consider these decisions or having to, manage these issues for you. And having a complete, well-written estate plan can be a huge relief for your kids if they're trying to help you. One bonus document, since we're talking about kids, there is a document that's not part of a typical estate plan, but it's called an authorization agreement for a voluntary adult caregiver. And this can be really useful for situations where, let's say, you and your girlfriends or your best friends are going on a cruise in the Caribbean, and you're leaving your kids with, let's say, your parents for a week. If you fill out one of these forms with the help of an attorney, it would authorize your parents to do things like make sure they get medical care if they need to go to the ER, and take care of things like that would happen in a limited period of time. So not talking about your incapacity or your death, but just a short period of time where you want someone to have the authority to make decisions on your behalf for your kids. So just wanted to mention that. And I haven't seen any questions pop up. If you have any questions, feel free to type them in. If you think of any questions later, I put my email address and my phone number there on this slide. If you check out my website if you want to look for some additional information about any of these documents. I have some more information about the documents. I go into more detail on my website. But that is all of the information I plan to present today. And again, if you have any questions, feel free to reach out. I strongly encourage you to reach out to Texas Legal if you have any needs for estate planning or family law or anything like that. They're great to work with. And I'm just going to sit tight for a few minutes to see if any questions come in. But thank you for taking the time to watch. This is one of my favorite topics to discuss. It's one of the reasons people reach out to estate planning attorneys, is because they've had kids and they're concerned about who's going to take care of them, and it's a good reason to think about estate planning for sure. Thanks, Denise. All right, so it looks like there may not be any questions. So I'm just going to say again, feel free to reach out by email or phone. And I want to thank Texas Legal for inviting me to talk about this topic. And